Strap in, everyone, because this case right here is the kind of courtroom moment that looks simple on the surface, but turns into an emotional, high-stakes unraveling the deeper we go. Today, we're diving into the probation revocation hearing of Nathan Wesley Huey, a man who's standing before the court after an initial conviction for physical control of a motor vehicle. Now, normally, you'd expect a straightforward case. Follow probation rules, stay clean, complete treatment, and move forward with life. But this case, it becomes something else entirely. We're talking addiction struggles, a controversial substance the court believes is far more dangerous than most people realize, and a defendant who's really trying to steer his life in a new direction. You're going to hear a judge who doesn't hold back, calling out government officials, calling out treatment centers, and calling out the failings in the system itself. This isn't just a legal proceeding. It is a raw, emotional confrontation between a man battling addiction, a court desperately trying to keep him alive, and a justice system grappling with a substance they believe is being dangerously overlooked. And the stakes? They skyrocket fast. You'll watch as the judge seriously considers sending Huey straight to jail for his own safety. You will see the shock on everyone's face when a new drug screen comes back positive that very morning. And by the end, you'll witness whether this entire courtroom believes rehabilitation or incarceration is the right path forward. So buckle up, because this case has twists, heartbreak, accountability, and controversy written all over it. Let's get into it.
Court is on the record in State of Ohio versus Nathan Wesley Huey, case number 25 TRC 414. In this case, Mr. Huey was convicted of physical control of a motor vehicle, a first-degree misdemeanor, back on August 25th, 2025. As part of his sentence, I ordered the defendant, I placed him on supervised community control with this court for 30 months with several conditions, one of which was to submit to a comprehensive diagnostic assessment at the community counseling center and comply with all recommended course of treatment. That was to be done within 30 days. I also specifically addressed, which is unusual for me, as part of the condition that he remain drug and alcohol free, that he specifically be prohibited from using or possessing kratom. I even made a note on my judgment entry, which is unusual, that the defendant is addicted to kratom, and that the community counseling center or any other agency to treat and test for kratom, or to treat and test the defendant for kratom. On October 20th, 2025, a probation violation complaint was filed by the probation department against Mr. Huey, which alleges that he failed to abstain from drugs of abuse by failing a urine drug screen on October 15th of 2025 for kratom. At a preliminary revocation hearing on November 3rd, 2025, the defendant entered a not guilty plea or denied the probation violation complaint, and so this case is set today for a final revocation hearing. Mr. Huey, who was not represented at the preliminary revocation hearing with counsel, is today present with retained counsel William Bobalski. Also present is Law Director John Lewis and Probation Officer Sean Benoit. Mr. Lewis, can you advise us of the status of this case, please?
Yes, sir. Your Honor, the offer that's been extended to Mr. Huey would be an admission of the probation violation. With that admission, the State of Ohio would recommend an extension of his supervision of a term of 6 months. And also, if he is deemed eligible, that he participate in the court's post-conviction renewal court program. And Mr. Huey has submitted an application for that program, which my office has signed off on. And based on my conversations with Mr. Bolsky, I believe that he and Mr. Huey are in agreement with this proposal, and the matter could be resolved today. Thank you.
Thank you. Mr. Bobolski?
Your Honor, Mr. Lewis has correctly stated the discussions that have taken place. I have discussed this matter with my client. I have heard from the court's probation officer, have discussed specifically the availability of the resource that this court has established in the form of its renewal court. My client is employed on a full-time basis with Worthington Cylinders. He has at work a more or less continuing review of his performance. We don't want any slip up in his life or in his work, and we welcome the opportunity to participate in the renewal court if the court sees fit to grant this application, because I think it is in, and he agrees that it is in his best interest and understands what the goals and purposes of that court are.
Thank you, sir. Mr. Huey, it's my understanding today that you wish to admit to the probation violation complaint that was filed against you on October 20th, 2025, or that would be a change of your plea to a guilty to that complaint. Is that what you wish to do today?
Yes, Your Honor.
You understand by admitting or pleading guilty to this complaint that you're waiving your right to a final revocation hearing, which means you'd be waiving your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses, as well as your right to be proven guilty by a preponderance of the evidence. All of those are hearing rights you'd be waiving by pleading guilty or admitting to this complaint. Is that what you wish to do today?
Yes, Your Honor.
You are represented by Mr. Bobolski. Have you had sufficient time to consult with him, and are you satisfied with his counsel?
Yes, Your Honor.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, Your Honor.
Are you currently on probation, parole, community control, or post-release control with any other court?
No, Your Honor.
Has anyone made any promises to you about what your sentence will be in order to induce you to admit or plead guilty to this complaint today?
No, Your Honor.
And are you thinking clearly, and do you understand everything that's happening?
Yes, Your Honor.
Okay, I'm going to provide to you, Mr. Bobolski, a waiver of hearing rights on probation violation cases. If you find that document acceptable, you can sign in or leave it at the bottom. Thank you. The court does find that Mr. Huey and Mr. Bobolski have executed in open court the written waiver. The court does find the defendant's admission or plea of guilty to the probation violation complaint filed against him on October 20th, 2025 to be knowing, voluntary, and intelligent. The court will accept the guilty plea, and I will therefore find him guilty of having violated his probation in this case. Mr. Bobolski, is there anything further that you would like to say before I impose sentence?
Your Honor, I have indicated to the court of my client's employment and his intentions and willingness to participate in the therapeutic program that I think addresses the issue that brings us here today. So, nothing further.
Thank you. Mr. Huey, is there anything you would like to say before I impose sentence?
Your Honor, I'm ready to make a change in my mind. I'm just done with it. You know, it's time to move forward. That's all I got to say.
Thank you. Mr. Lewis, anything further?
I have nothing to add other than I'm happy that Mr. Huey has agreed to do renewal court. Thank you.
Mr. Our Officer Benoit.
Just letting the court know that we did conduct another urine drug screen this morning on Mr. Huey, where he once again failed for grading, Your Honor.
This is the bombshell moment. Think about it. Huey walked into court today hoping to accept responsibility, get an extension, and enter a rehabilitation program, and then the probation officer drops the news that he failed another drug test just hours before the hearing. This is where everything shifts. What was headed toward an administrative, almost routine hearing suddenly becomes a crisis intervention. From the court's perspective, this signals one thing: Huey is in deeper than he realizes. Addiction doesn't take breaks for court dates, and this positive test proves he's still physically dependent. If you're watching this, ask yourself, do you think this was self-sabotage? A moment of panic? Or is it simply the reality of addiction overpowering intention? Because this one result is about to shape the judge's entire approach for the rest of the hearing.
Thank you. So, Mr. Huey, our renewal court program has been around for a few years now, and just recently we have a, well, actually he's a current participant who was addicted to kratom. And I may have said this in your case before. If I did, I apologize. I'm going to say it again. This is a guy who was previously addicted to any and all other drugs and substances that is known to man that's on the streets, whether it be meth or heroin or what have you, and who has experienced withdrawals from those drugs. He said when we finally addressed the issue, which means it was addressed with him in jail, that he never experienced such a horrible withdrawal from all of the drugs, more horrible than he did from kratom. For some reason, our government leaders seem to think that kratom should remain illegal. Shame on them. Shame on Secretary Kennedy. Shame on Governor DeWine. Shame on everyone who continues to promote kratom as being a legal substance with benefits. You, Mr. Huey, are suffering from kratom addiction. And for you to come off of it, it's going to take medical detox. I could have you arrested today. In fact, I thought about it, so you could detox. But from what I understand, it's not very pleasant. And the last place you need to be with no criminal history, you shouldn't be detoxing in a jail. You need to be detoxing in a medical facility. And there are plenty of facilities out there. And then, after that, you need to get into treatment. Did he ever get assessed by Community Counseling Center?
You did, Your Honor. Does client meet criteria for substance use disorder diagnosis? No. Counseling would be beneficial. Nathan reports he's intending to celebrate recovery. He's been clean and sober. He reported this, that he was clean and sober for 10 years.
You're not going back to Community Counseling Center. That's a horrible assessment report. Absolutely mind-blowing. And I understand that these assessments are based on self-reporting. So you weren't honest with them, were you?
I was, for the most part. Yes.
You were? Did you tell them about kratom?
Yes, I told them I was taking kratom.
Okay, well then shame on them. Especially when my order reflected that they were to assess you for kratom addiction and to test you. Shame on them. And I'll address it with them after this hearing. Okay. I'm not going to order you to medical detox. You need to go, though. You need to go. You want to change your life? You have to go. Because you know what? If you test positive for kratom again, whether it be before renewal court or after renewal court, if you're eligible, you're going to jail. And you're going to detox there. I will extend his probation for 6 months. I'm going to order that he undergo an assessment for substance abuse and mental health purposes at the Lake Area Recovery Center. I am going to add to the conditions of his sentence that he successfully participate and complete renewal court. This court's intensive substance abuse and mental health specialized docket, if he is deemed eligible after all the assessments are completed. Now, we do require a mental health assessment. I don't know if that mental health assessment from the community counseling center will suffice for renewal court, but there are going to be some screenings and assessments you'll have to undergo before you're determined eligible for renewal court. If you are determined eligible for renewal court, we're going to have another hearing welcoming you into the program. And Mr. Bobolski certainly welcome to be present, although he doesn't necessarily have to be. And then we'll get things rolling from there.
There you are.
Yes.
My client has made contact with the program at Glen Bay. We try very hard to get people to Glen Bay, but the insurance requirements often are prohibitive. Is Glen Bay acceptable to?
In lieu of LARC,
Yes.
is he going to seek detox there? They do have a detox.
Yeah, whatever they tell him to do.
I have an appointment at 1 o'clock on Wednesday.
At Glen Bay.
Yes.
Yeah, we'll change that to Glen Bay. And they've already pre-approved you. They've accepted your insurance and everything.
Yes.
Yeah, Glen Bay will soon be a partner with our renewal court. They're not yet, but they will be. So, yeah, I mean, you need detox. I'm not going to order it though. I mean, if I were you, Mr. Huey, I know your job is on the line. I don't want to see you lose your job, but you need at least 72 hours detox, at least. You need to go to a facility to get off of this stuff. I mean, you're going to need help doing it. So, okay, so we'll just change that to Glen Bay, and you'll have to sign releases to Glen Bay so our officer can monitor how things are going there. Don't come back to me with another probation violation, understood?
Understood.
Okay. You do have a right to appeal. You have a right to appeal without cost. You have a right to have counsel appointed on appeal without cost. You have a right to have documents provided to you necessary to file an appeal without cost, and you have a right to have a notice of appeal timely filed on your behalf. The 177 days which were originally suspended will continue to be suspended. Anything further, Mr. Lewis?
No, Your Honor.
Mr. Bobolski? Officer Benoit?
No, Your Honor, thank you.
Okay, thank you all very much. This matter is concluded.
What a powerful and complicated case. In the end, the court chose a path rooted in rehabilitation rather than punishment, extending Huey's probation by 6 months, ordering a new assessment, and steering him toward intensive treatment through Glen Bay and possibly the renewal court program. The judge made it abundantly clear. This wasn't about legal technicalities anymore. This was about saving a man from an addiction she believes is far more dangerous than the public realizes. And with Huey's repeated positive tests, his future now depends on his willingness to fully commit to detox and recovery. This hearing highlights an important truth in the justice system. Addiction cases demand nuance, compassion, and firm boundaries. One more misstep, and Huey faces jail time. But if he embraces the help being offered, this could be the turning point he desperately needs. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.